Hello, today's topic is trusts. So what is a trust? A trust is a legally enforceable obligation placed by one person called the settlor on another person called the trustee. The obligation which is placed on the trustee is that he must deal with certain specified goods or money in certain specified ways for the benefit of another person called the beneficiary. The law of trust is codified in India under the Indian Trust Act of 1882. Now let's look at the trust and the settlor's role in creating a trust in a bit more detail. A trust is normally created when the settlor indicates with certainty either by words or act that there is an intention on his part to create a trust. He sets down the purpose of the trust, sets out the beneficiaries involved, and then lists the trust property itself, and then transfers the trust property to the trustees. So who can create a trust? Actually, anyone who is competent enough to contract can create a trust. In fact, it can be created on behalf of a minor as well, with the permission of a civil court. The different types of trusts are public trusts and private trusts. A public trust can be further subdivided into charitable trusts and religious trusts. With regard to the tax position, as provided certain conditions are met, a public trust is exempt from tax if the income it receives is used for charitable or religious purposes. We know about retirement trusts. Approved retirement trusts, which are commonly set up by employers, are also exempt from tax. With regard to private trusts, if the beneficial interest is absolute, then any income rising is added to the beneficiary's taxable income. In other words, it is taxable. In the event of a discretionary trust, the entire income is taxable in the hands of the trustees. Now, classification of trusts. This depends on the type of power which has been given to the trustees by the settlor. Let's consider express trusts and implied trusts. So what are the different types of express trusts? A discretionary trust is an express trust. A fixed trust is an express trust. A living trust or inter vivos trust. Other examples are charitable trusts, will trusts. If we consider the power of a trustee, the powers of a trustee cover administrative powers as well as dispositive powers. The rights and powers of a trustee, as set out in the Indian Trust Act of 1882, include the right to possession of the title deed, right to reimbursement for his expenses, right to be recouped for erroneous overpayment, right to indemnify from gainer by breach of trust. The other rights include right to settlement of accounts. As far as powers are concerned, he has the power to vary investments, power to sell under certain conditions, power to apply property of minors for their maintenance. With power, of course, there are the duties of a trustee. The duties include he is required to acquaint himself with the nature and circumstances of the trust property. In other words, he needs to know the details of the property itself. He is required to protect title to trust property. He is bound to deal with the trust property as carefully as a man of ordinary prudence who would deal with such property as if it were his own. In other words, he must apply utmost care. Trustee must be impartial. He must prevent waste. He is bound to keep clear and accurate accounts of the trust property, and at all reasonable times, at the request of the beneficiary, provide the beneficiary with full and accurate information as to the amount and state of the trust property. In other words, a status report. So how can a trustee discharge his duties? It is discharged by the extinction of the trust. In other words, when the trust comes to an end. It is discharged by the completion of the duties of a trustee. It is discharged by means prescribed by the instrument of trust. In other words, the conditions set out in the trust document. It is by the appointment. It is discharged by the appointment under the trust of a new trustee. It can also be discharged by consent of himself and the beneficiary. It can also be discharged by the court to which a petition for his discharge is presented under the Act. So what are the advantages of setting up a trust? The advantages are mainly as follows. It allows for the orderly distribution of assets in the event of death. The estate can be managed professionally at an arm's length, for example by trust corporations. It ensures that the estates pass to the intended beneficiaries. It protects from debtors. And also, it can be used as a planning tool to transfer income to beneficiaries under these specific circumstances. So finally, how does trust help in estate planning? In the earlier chapter, we mentioned that estate planning covers conservation, accumulation, and distribution of assets. With regard to conservation, we can see that the trust can be used to protect from debtors. With regard to accumulation, trust can be used to ensure that wealth accumulated over a lifetime is not divided up among heirs but retained as one fund to increase it further. And finally, distribution. Clearly, trust can be used to distribute all the wealth that has been built up in an orderly and a definite manner. Thank you.